Welcome to Chapter 13 of Criminal Procedure. The courtroom, the pretrial and trial process. This is one of the longest and most content-dense chapters in the course, which is why I've expanded this to 16 slides. This chapter covers the full arc of the pretrial and trial process in American criminal courts, from the point where the first appearance ends all the way through jury deliberations, jury nullification, and guilty pleas. As you move through the material, keep asking yourself, where is the balance being struck between the government's interest in prosecuting crime and the individual's interest in being treated fairly? Chapter 13 has 13 learning objectives, more than most chapters, reflecting the breadth of the material. Objectives 13.1 through 13.4 cover the pretrial phase, preliminary hearings, grand juries, arraignments, and the various pretrial motions including double jeopardy, speedy trial, change of venue, discovery, and suppression. Objectives 13.5 and 13.6 address when a jury trial is constitutionally required and the minimum number of jurors. Objectives 13.7 and 13.8 cover jury selection, including the fair cross-section requirement, the equal protection, voir dire, and Batson. Objective 13.9 covers judicial recusal. Objective 13.10 covers the right to a public trial. Objective 13.11 walks through the stages of the trial. Objective 13.12 covers jury nullification, and Objective 13.13 covers guilty pleas and plea bargaining. Following the first appearance, the criminal process moves to establishing whether there is sufficient cause to bring the case to trial. The preliminary hearing is a mini-trial, public, adversarial, with the defendant represented by counsel. The prosecutor presents witnesses, the defense cross-examines, and a magistrate determines whether sufficient evidence exists to bind the defendant over for trial. The standard is either probable cause, a fair probability of conviction, or in some states, a prima facie case sufficient to convict if the evidence is believed. The preliminary hearing's purpose is to prevent hasty, malicious, and oppressive prosecutions. It is not, however, constitutionally required. States are categorized as indictment states, 18 plus DC, and the federal government, where felony charges must go to a grand jury. Information states, where prosecutors file sworn charges directly, and modified indictment states, which require grand juries only for the most serious offenses. The grand jury originated in 1166 England and is now unique to the United States. The Fifth Amendment requires grand jury indictment for federal infamous crimes, offenses punishable by more than 1 year in prison. States are not required to use a grand jury following Hurtado v. California in 1884. The grand jury has between 16 and 23 members federally, operates in complete secrecy, and the defendant is not present and is not represented by counsel. Rules of evidence generally don't apply. Hearsay and even unlawfully seized evidence may be presented. The grand jury may return a true bill, or an indictment, a no bill, a refusal to indict, or issue a presentment, which is an independent investigation report. The grand jury can subpoena both witnesses and documents. Critics call it a rubber stamp for prosecutors. Former federal judge William Campbell famously said a prosecutor could indict a ham sandwich. Defenders argue that the grand jury represents popular participation in the justice system and provides a check on overzealous prosecution. The failure of grand juries to return indictments in high-profile police killing cases in Ferguson and Staten Island intensified calls for reform. The arraignment. The defendant is formally informed of the charges and enters a plea. The 4 possible pleas are not guilty by reason of insanity, nolo contendere, and guilty. The nolo contendere plea, no contest, is strategically important because it carries all the consequences of a guilty plea, except that unlike a guilty conviction, it cannot be admitted into evidence in a civil trial to establish that the defendant committed the act. This is why defendants who anticipate related civil liability sometimes prefer it. Double jeopardy is one of the most fundamental protections in the American constitutional system, with roots reaching back to ancient Greece, Roman law, the Magna Carta, and Blackstone's commentaries. The Fifth Amendment's double jeopardy clause provides three distinct protections: against a second prosecution after acquittal, against a second prosecution after conviction, and against multiple punishments for the same offense. Jeopardy attaches, meaning the protection kicks in at different points depending on the type of proceeding. In a jury trial, jeopardy attaches when the jury is impaneled and sworn. This was reaffirmed in Martinez v. Illinois in 2014, where the prosecutor refused to present evidence after the jury was sworn, and the Supreme Court held that the directed verdict of acquittal was a true acquittal that barred retrial. In a bench trial, jeopardy attaches when the first witness is sworn. On a guilty plea, jeopardy attaches when the judge accepts the plea and enters a conviction. Key exceptions that permit a second trial despite jeopardy having attached include a mistrial declared on the defendant's motion or with consent, because the defendant waives double jeopardy by requesting the mistrial, unless the prosecutor intentionally goaded the request, a mistrial based on manifest necessity over the defendant's objection, such as a hung jury or a fatal defect in the indictment that makes reversal certain on appeal, a defendant who appeals and wins because they waive double jeopardy by appealing, and the dual sovereignty doctrine, which allows both a state and a federal government to prosecute the same criminal act because they are enforcing separate laws. The Blockberger test determines what counts as the same offense. Two statutes constitute the same offense only if neither requires proof of a fact that the other does not. Three of the most important pretrial motions are the speedy trial claim, change of venue, and Brady discovery. The Sixth Amendment right to a speedy trial traces to the Magna Carta. The remedy, dismissal of all charges, is so drastic that courts are reluctant to find violations. In Barker v. Wingo, the Supreme Court identified a four-factor balancing test. The length of the delay is the triggering factor. It must be presumptively prejudicial to require analysis of the others. The reason for the delay is weighted differently. An intentional delay weighs heavily against the government. A neutral reason, like a crowded docket, weighs less heavily. A delay caused by the defendant weighs against the defendant. Whether the defendant asserted the right and whether the defendant suffered actual prejudice both factor into the analysis. The Speedy Trial Act of 1974 gave concrete deadlines: indictment within 30 days of arrest, arraignment within 10, trial within 70. Change of venue is required when publicity has so permeated the community that a fair trial is impossible. The classic presumed prejudice cases, Shepard v. Maxwell, where Bedlam reigned at the courthouse, and Rideau v. Louisiana, where two-thirds of the community had watched the defendant's televised confession, show the extremes. The modern trend reflected in Irvin v. Dowd and Skilling v. United States is toward an actual prejudice standard. Can the jurors, despite exposure, honestly decide based solely on the evidence? In Skilling, despite the complete financial collapse of Enron devastating Houston's economy, the court found no actual prejudice because the trial occurred 4 years after the scandal. The city was large and diverse, and the jury questionnaire and voir dire thoroughly screened for bias. Brady v. Maryland in 1963 established that the Due Process Clause requires prosecutors to disclose exculpatory evidence material to the defendant's guilt, innocence, or sentence. The standard is materiality. The suppressed evidence must create a reasonable probability of a different result if disclosed. This seemingly narrow standard has been violated with distressing frequency. In Smith v. Kane, the eyewitness's prior statements that he could not identify anyone were plainly material and undermined confidence in the conviction. In Weary v. Kane, the court stressed that Brady evidence is evaluated cumulatively. Prosecutors cannot simply isolate each withheld piece of evidence and conclude that none of it would have changed the outcome. Constitutional right to a trial by jury reflects one of the oldest protections in the Anglo-American legal tradition. In Duncan v. Louisiana in 1968, the Supreme Court incorporated this right into the 14th Amendment and held that jury trials are required for serious criminal cases, those carrying more than 6 months imprisonment. The distinction between serious and petty offenses is based on the authorized penalty under the statute, not the penalty actually imposed. If the legislature has authorized imprisonment of more than 6 months, the defendant has a constitutional right to a jury trial. Gary Duncan's case illustrates why. A 19-year-old black man was prosecuted for touching the arm of a white student who was intimidating black classmates. Without a jury, there was no check on this prosecution. On jury size, in Williams v. Florida in 1970, the Supreme Court held that 12 jurors is not constitutionally required. It's a historical accident. Florida's 6-person jury serves the same functions. 6-person juries can represent a cross-section of the community and engage in a vigorous debate. But how small is too small? Ballou v. Georgia in 1978 drew the line at 5. The court relied extensively on social science research to conclude that 5-person juries are less likely to engage in effective deliberation, are at higher risk of convicting the innocent, produce more inconsistent verdicts, and underrepresent minority viewpoints. The 5-person jury is unconstitutional. 6 is the constitutional minimum. The court acknowledged that the line between 5 and 6 is somewhat arbitrary, but concluded that the accumulated evidence raised sufficient doubt about 5-person juries to condemn them to constitutionality. Jury selection is one of the most critical, important, and constitutionally regulated aspects of the criminal trial. 2 constitutional provisions regulate the process. The Equal Protection Clause of the 14th Amendment prohibits the intentional exclusion of individuals from the jury based on race, ethnicity, gender, or religion. The key word is intentional. The defendant must establish a prima facie case of discrimination. The rule of exclusion from Norris v. Alabama allows a presumption of discrimination where there is substantial underrepresentation of a group combined with a selection system easily subject to manipulation. The Sixth Amendment's fair cross-section requirement is different in 2 important ways. First, the Duren 3-part test does not require proof of intent. Systematic exclusion over time is sufficient. Second, a defendant may challenge underrepresentation of a group they don't belong to because the cross-section requirement protects the integrity of the process itself, not just the defendant's personal rights. On voir dire, the questioning of potential jurors determines who will ultimately decide the defendant's fate. Lawyers use challenges for cause based on specific demonstrated bias, theoretically unlimited, and preemptory challenges that have no reason required and are limited in number. In capital cases, jurors who state they could never vote for death may be excluded for cause as Witherspoon excludables. In Lockhart v. McCree, the Supreme Court held that death-qualified juries are constitutional because those excluded are defined by an attitude that prevents them from performing their jury duty, not by an immutable characteristic like race or gender. The dissent argued powerfully that the evidence shows death-qualified juries are more conviction-prone, creating a systematic disadvantage for capital defendants. The use of preemptory challenges has been one of the most contested areas of jury law in the last 4 decades. For most of American history, preemptory challenges were nearly unreviewable. Swain v. Alabama in 1965 confirmed that lawyers could exclude jurors based on race so long as no specific discriminatory intent could be proven, an essentially impossible burden for defendants to meet. Batson v. Kentucky in 1986 changed this fundamentally. The Equal Protection Clause prohibits using peremptory challenges to exclude jurors solely on account of their race. The 3-step Batson process works as follows. The defendant must first demonstrate facts from which discrimination may be inferred. the pattern of strikes, the questions asked, the race of remaining jurors. The burden then shifts to the prosecutor to provide a race-neutral explanation. Finally, the judge determines whether the explanation is genuine or pretextual. J.E.B. v. Alabama in 1994 extended Batson to gender. Powers v. Ohio established that defendants may challenge discrimination against a racial group they don't belong to because the integrity of the process is at stake. The subsequent history shows Batson's practical limitations. Foster v. Chapman in 2016 revealed that the prosecution's files had the letter N marked next to every black juror's name. Chief Justice Roberts held that 2 race-based strikes are 2 more than the Constitution allows. Flowers v. Mississippi in 2019, involving the same defendant, tried 6 times by the same prosecutor, showed that 41 of 42 black prospective jurors were struck over the course of those trials, with 145 questions directed at black jurors versus 12 at seated white jurors. This documented pattern of systematic discrimination finally resulted in reversal. Arizona's Supreme Court went the furthest in 2021, abolishing peremptory challenges entirely on the grounds that Batson protections had proven insufficient to stop their discriminatory use. The right to a public trial is one of the oldest procedural protections in American law. It serves multiple purposes: protecting defendants from secret prosecutions, ensuring judicial fairness, attracting witnesses who might otherwise stay silent, and promoting honesty in testimony. The right extends beyond the trial itself to all hearings with a reasonably substantial relationship to the defendant's defense. Preliminary hearings, suppression hearings, jury selection, jury instructions, and sentencing. It does not extend to pure bench conferences on legal points. Press and public closure is permitted only in narrow circumstances requiring a compelling government interest that it is narrowly tailored, meaning courts should close the smallest portion of the proceedings necessary. Accepted grounds include preventing prejudicial pretrial publicity, protecting juvenile victims of sexual abuse from further trauma, and protecting classified national security information. A defendant does not have an absolute right to be present. In Illinois v. Allen, an unruly defendant was removed from the courtroom. The court approved 3 responses in order of preference: removal citing for contempt, and as a last resort, binding and gagging, noting that binding and gagging risk prejudicing the jury, interfering with the attorney-client relationship, and undermining the dignity of the proceedings. Although this isn't exactly on point, this also carries over into civil law. One of my very first jury trials when I had moved from being a prosecutor to being an defense attorney included a case by a pro se litigant who was the plaintiff in the case suing the sheriff's department that my firm represented. And part of what happened was when we went to the jury trial, he had to appear via video. He was considered too dangerous to appear in person and be transported. And on the first day of the trial, he appeared in a suit on the video. However, after the first day, and after refusing to give back the pencils and the paper that he was using for his trial, and then attempting to stab one of the officers who was attending him, it was determined by the court that he had to be handcuffed during his trial because he was a danger to the jail staff and officers who were maintaining him at the facility once the trial was over. So he had to appear shackled in front of the jury via video. Frankly, he could have remained unaware to the jury of his shackling by keeping his hands down below the camera. However, as soon as day 2 of the jury trial started and as soon as the jury got seated, he immediately took his hands up in front of the video screen and yelled, "Look at how they're keeping me, treating me like an animal." I think that ultimately was his goal, to get some sort of sympathy from the jury. it didn't work. All the jury saw was that he was a convicted felon and he was sitting in jail and that he was clearly dangerous because he had to keep his cuffs on. So, while this concept that we're discussing here is strictly for criminal purposes, similar concept applies in civil cases. People can be restrained if the need so arises, and frankly, they can be removed if they don't cooperate with the judicial process. On challenges to judges, the Due Process Clause guarantees a neutral and impartial judge. The standard is objective, not whether the judge admits to bias, but whether the average judge in the same position would likely be neutral. Caperton v. Massey showed that extraordinary campaign contributions can cross the line into creating an unconstitutional risk of actual bias. Williams v. Pennsylvania showed that a judge who previously authorized seeking the death penalty in the same case cannot preside over an appeal of that sentence. No man can be judge in his own case. Two of the most important rights at trial are the Confrontation Clause and the Compulsory Process Clause. The Confrontation Clause guarantees face-to-face confrontation and cross-examination. Wigmore called cross-examination the greatest legal engine ever invented for the discovery of the truth, and the Supreme Court has treated it as the central right protected by the Confrontation Clause. Crawford v. Washington in 2004 fundamentally restructured Confrontation Clause doctrine. The court drew a critical distinction between testimonial and non-testimonial statements. Testimonial statements, those made in the context of a formal legal proceeding or police interrogation conducted to gather evidence for trial, are inadmissible against the defendant unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine. This replaced the older reliability-based analysis from Ohio v. Roberts. Non-testimonial statements are those made during ongoing emergencies where the primary purpose was to respond to the emergency rather than gathering trial evidence. Davis v. Washington held that 911 calls where the caller is describing an ongoing emergency are non-testimonial. Michigan v. Bryant held that a dying victim's statements to the police identifying his shooter were non-testimonial because the shooter's location was unknown and there was a continuing threat to the public. Ohio v. Clark held that a 3-year-old's statements to teachers identifying her abuser were non-testimonial because the teacher's primary purpose was protecting the child. Melendez-Diaz and Bullcoming established the lab analyst rule. If a crime laboratory report is used at trial, the analyst who conducted the test must testify and be subject to cross-examination. Sworn affidavits are not sufficient. This gives the defense the opportunity to probe whether the test was conducted properly and whether the results actually support the conclusions that were reached. On burden of proof, In re Winship established that proof beyond a reasonable doubt on every element of every charged offense is constitutionally required under the Due Process Clause. The prosecution bears both the burden of production and the burden of persuasion. The defendant is presumed innocent, need not testify, and the prosecutor may not comment on the defendant's silence. Closing arguments and jury instructions are the final opportunities for lawyers and the judge to shape how the jury approaches its deliberations. On closing arguments, the prosecution goes first, the defense responds, and then the prosecution has the final word. The prosecution gets the last word because it bears the burden of proof and should be able to rebut defense arguments. The American Bar Association standards prohibit a range of closing argument conduct: intentional misstatements, arguments unsupported by the evidence, personal opinions on evidence or guilt, references to social consequences of verdicts, inflammatory emotional appeals, and negative inferences from defendants exercising constitutional rights. The Supreme Court applies a totality of the circumstances analysis, with the key question being whether the argument so infected the trial with unfairness as to deny due process, a standard that courts rarely find satisfied. The invited response doctrine is important. When a prosecutor's closing argument directly responds to defense arguments, courts are more likely to find it non-prejudicial because it was an effort to right the scale. Darden versus Wainwright is the most extreme example, calling the defendant an animal, expressing regret the victim couldn't have shot the defendant, and even that did not warrant reversal because the evidence was overwhelming and much of the objectionable content was invited by the defense's summation. On jury instructions, the judge's instructions serve as the legal roadmap for deliberations. Standard instructions include: the judge decides the law, jury finds the facts, presumption of innocence, prosecution's burden, elements of the offense, and deliberation procedures. The reasonable doubt standard itself must be communicated clearly. The Constitution doesn't require any particular formula, but the instructions as a whole must convey the requirement of near certitude of guilt. Cage v. Louisiana shows the failure mode, equating reasonable doubt with a grave uncertainty or actual substantial doubt sets too low a bar and violates due process. Victor v. Nebraska shows an acceptable formulation, abiding conviction to a moral certainty, because that phrase, read in context, adequately communicates the high standard required. Jury deliberations are the most private phase of the criminal justice process, and the law has constructed strong protections around them while also recognizing specific exceptions where transparency is necessary. During deliberations, jurors receive copies of charges and instructions, may review exhibits, and in most jurisdictions may request to review specific testimony. If a jury is deadlocked, the judge may issue the Allen charge, also called the dynamite charge, instructing both majority and minority jurors to reconsider whether their view is reasonable in light of the disagreement. The judge has considerable discretion in deciding when to declare a mistrial for a hung jury, as the Supreme Court affirmed in Renico v. Lett. The no impeachment rule prohibits jurors from testifying about what happened during deliberations. Federal Rule of Evidence 606B codifies this principle. The rationale is protecting the finality of verdicts, encouraging candid deliberations, and shielding jurors from post-verdict harassment. The rule has two statutory exceptions: prejudicial information brought to jurors' attention improperly and outside influences, but courts interpret these narrowly. Warger v. Showers in 2014 applied the no impeachment rule even where the foreperson had concealed her daughter's auto accident during voir dire. This was a striking result. The foreperson almost certainly would have been struck from the jury if she had been honest, but the court held that the no impeachment rule applied. Pena Rodriguez v. Colorado in 2017 created a new exception for racial bias. When a juror makes a clear statement indicating reliance on racial stereotypes or animus to convict a criminal defendant, the Sixth Amendment requires the no impeachment rule to give way so the trial court can consider the evidence. Justice Kennedy's majority opinion characterized racial discrimination as a familiar and recurring evil that, if left unaddressed, would risk systemic injury to the administration of justice. Racial bias, the court found, was categorically different from the ordinary irregularities that the no impeachment rule is designed to protect. The dissent worried that the majority had no principled basis for limiting the exception to race rather than extending it to other forms of prejudice like religion or ethnicity. The unanimity requirement and jury nullification sit at opposite ends of the spectrum involving how much control the law exercises over jury decision-making. On unanimous jury verdicts, Apodaca v. Oregon in 1972 was one of the most fractured and intellectually confused decisions the Supreme Court ever issued on a constitutional question. The result was that the Sixth Amendment unanimous jury requirement, which had been uniformly understood as fundamental, was held not to apply to the states. Oregon and Louisiana could convict on 10-2 and 9-3 votes, respectively. In 2020, Ramos v. Louisiana swept Apodaca away. Justice Gorsuch's majority opinion traced the history of the unanimous jury verdict requirement and found it firmly established at the time of the Sixth Amendment's ratification. He was also pointed about the precedential value of Apodaca. No one on the court was willing to defend it as correctly decided, and stare decisis was not a shield for decisions that everyone recognized as wrong. Gorsuch also noted that non-unanimous verdict laws in both Louisiana and Oregon had been enacted as deliberate efforts to prevent black jurors from blocking convictions of minority defendants. A tainted history that further weakened the argument to preserve the practice. Unanimous jury verdicts are now required in all state and federal criminal trials. Edwards v. Vinoy in 2021 held that Ramos does not apply retroactively in federal habeas corpus proceedings, meaning individuals convicted by non-unanimous juries before Ramos cannot seek federal relief on that basis alone. On jury nullification, the jury has the practical and unreviewable power to acquit regardless of the evidence, because acquittals cannot be appealed. This power has a distinguished history. Peter Zenger, the fugitive slave cases, but also a shameful history in Southern civil rights era prosecutions. The law's current position is deliberately ambiguous. Juries have the power, but judges don't have to tell them about it, and courts actively discourage its exercise. This tension between acknowledging the power and discouraging its use is an intentional feature of the system. The guilty plea is the dominant mechanism of criminal adjudication in the United States. 94 to 97% of criminal cases are resolved this way. The constitutional drama of the jury trial is, in practice, the rare exception. The three types of plea bargains: charge bargains, sentence bargains, and sentence recommendation bargains, each offer defendants something in exchange for waiving three constitutional rights: the Fifth Amendment right against self-incrimination, the Sixth Amendment right to trial, and the Sixth Amendment right to confront and cross-examine witnesses. The Supreme Court has upheld plea bargaining as constitutional and, in Santabello v. New York, called it essential to the administration of justice. The court in Brady v. United States established that a plea motivated by fear of a worse outcome, including the death penalty, is not coerced so long as it represents a voluntary and intelligent choice among alternatives. Bordenkircher v. Hayes held that a prosecutor who warns a defendant that refusing to plead will result in a more serious charge based on prior convictions is not engaging in vindictive prosecution. This is the legitimate exercise of charging discretion and not retaliation. Before accepting a guilty plea, a judge must comply with Rule 11 of the Federal Rules of Criminal Procedure. The judge must personally address the defendant in open court, explain the charges and possible sentence, confirm the factual basis of the plea, and verify that the plea is voluntary and not the product of force, threats, or undisclosed promises. A defendant who pleads guilty also waives the right to challenge prior constitutional violations: an unlawful arrest, an illegal search, a coerced confession, unless the issue goes to the court's power to prosecute. Withdrawal standards are graduated by timing. Before acceptance, withdrawal is free. After acceptance, but before sentencing, the fair and just reason standard applies. After sentencing, only a miscarriage or manifest injustice justifies withdrawal. When the prosecutor breaches the agreement, as in Santabello, where a new prosecutor made a sentence recommendation contrary to the original deal, the defendant may withdraw. Missouri v. Fry and Lafler v. Cooper in 2012 established that the Sixth Amendment right to effective assistance of counsel applies fully to the plea bargaining process. Defense attorneys must communicate plea offers and provide competent advice about whether to accept. The court described plea bargains as not an adjunct to, but the criminal justice itself. North Carolina v. Alford is one of the most important and most debated cases in the history of guilty pleas. Henry Alford was indicted for first-degree murder, a capital offense in North Carolina. His lawyer questioned all but one of the witnesses Alford claimed would support his innocence. Not only did these witnesses not support Alford, they gave statements that strongly indicated his guilt. The prosecutor agreed to accept a plea to second-degree murder in exchange for sparing Alford from the possibility of death. Alford stood before the judge, insisted he had not committed the murder, and then pled guilty anyway. The Supreme Court held that the trial court had properly accepted the plea. The standard is not whether the defendant admits guilt. Admission of guilt is not a constitutional prerequisite for a valid guilty plea. The standard is whether the plea represents a voluntary and intelligent choice among the alternatives that are available. Given the overwhelming evidence against Alford, his rational calculation was that he had nothing to gain from trial and much to gain from pleading guilty. That is a constitutionally sufficient basis for accepting a plea. The Alford plea, a guilty plea accompanied by a protestation of innocence, is now accepted in most, but not all, jurisdictions. It differs from nolo contendere in one critical respect. An Alford plea results in a criminal conviction that can be used in related civil proceedings to establish liability. Nolo contendere cannot. Defendants and their lawyers must choose carefully between these options. The dissent from Justices Brennan, Douglas, and Marshall argued that the plea was a product of unconstitutional duress, the threat of the death penalty, and that Alford's contemporaneous denial of guilt should have been seen as indicating that the plea was not truly voluntary. This position did not prevail, but it represents a serious critique of allowing the government to structure choices in ways that make pleading guilty rational even for innocent defendants. The Alford case raises a profound question that the criminal justice system has not fully resolved. Is it appropriate to accept a system where rational actors facing an asymmetry of power and resources plead guilty to crimes they may not have committed in order to avoid a worse outcome? Let me bring Chapter 13 together with 6 comprehensive key takeaways. First, the preliminary hearing and grand jury both serve as probable cause gatekeepers, but differ fundamentally. The preliminary hearing is public, adversarial, and legally supervised. The grand jury is secret, non-adversarial, and prosecutor-controlled. Neither is constitutionally required for states, though the federal government requires the grand jury for infamous crimes. At arraignment, defendants enter pleas, including nolo contendere, which, unlike an Alford plea, cannot be used in civil litigation. Second, double jeopardy provides 3 constitutional protections. Jeopardy attaches when the jury is sworn. The Blockberger test determines what counts as the same offense. Key exceptions include mistrials on the defendant's motion or consent, manifest necessity mistrials, successful appeals waiving double jeopardy, and the dual sovereignty doctrine. Third, speedy trial is evaluated under Barker v. Wingo's 4-factor balancing test. Brady requires disclosure of material exculpatory evidence, assessed cumulatively, with materiality defined as reasonable probability of a different result. Change of venue requires demonstrative prejudice, with modern courts preferring the actual prejudice standard. Fourth, jury trial required for serious crimes, more than 6 months authorized. Minimum jury size is 6, 5 is unconstitutional. Veneer must reflect a fair cross-section. Batson prohibits race-based peremptory challenges. JEB prohibits gender-based challenges. Ramos v. Louisiana in 2020 requires unanimous verdicts in all criminal trials. Fifth, the Confrontation Clause under Crawford bars testimonial statements of unavailable witnesses without prior cross-examination. Non-testimonial emergency statements may be admitted. Lab analysts must testify in person. Every element must be proved beyond a reasonable doubt under Winship. Closing arguments must not infect the trial with unfairness. Pena-Rodriguez created a racial animus exception to the no impeachment rule for jury deliberations. Sixth, 94 to 97% of cases resolved by guilty plea. Pleas must be knowing, intelligent, and voluntary under Rule 11. North Carolina v. Alford permits guilty pleas while maintaining innocence where there is a strong factual basis. Defense attorneys have constitutional duties in plea bargaining under Frye and Lafler. Jury nullification exists as an unreviewable power, but judges need not inform juries of it. That concludes Chapter 13. Thanks for watching, and I'll see you in the next lecture.